Am I audible?
Yep.
Thank you for that. A very good evening to those who are joining us from India. And good morning, good afternoon to wherever you are. I, on the behalf of entire team of Accords International, welcome Espen Auber, our head for the day, and all of you, the participants who have joined us on the event, on the occasion of National Sports Day in India. Why we are keeping this, we'll talk about it in detail. I'll just give you a brief of what Accords is all about. So Accords International is an organization that deals with conflict resolution. We focus specifically on mediation and restorative justice, and we are also working on how to make mediation a restorative mediation. We formed this organization last year, and since then, we have been working diligently, tirelessly towards organizing unique events wherein we can inform our participants, young professionals, law students, about unique practices that in conflict resolution have been going on around the world. Today, we have with us Espen Auber. We just introduce you to him. Espen is a Norwegian attorney at law, partner and head of sports law at Nova Law. He has previously worked for the Norwegian Football Association as legal director and attorney at law for 10 years. He is currently a member of UEFA Legal Committee and president of the Norwegian Sports Law Association. Espen is certified as mediator by the Norwegian Bar Association and offers mediation primarily in sports-related disputes. Espen has been on the list of arbitrators as well at the Court of Arbitration for Sports since 2019 and has since arbitrated numerous cases as a part of panel and as a sole arbitrator. Since 2011, Espen has been working exclusively with sports law and football law. He has spent most of his professional life in the football industry and has gained substantial experience in football-related arbitration, litigation, and dispute resolution involving clubs, players, managers, agents, intermediaries, and other football stakeholders. Over the years, Espen has been involved in a large number of national and international disciplinary cases, such as on-field incidents and alleged breaches of transfer regulations and disciplinary regulations involving clubs, players, managers, coaches, and international associations, such as UEFA and FIFA. Thank you, Espen, for joining us today, and we look forward to have a great session with you. Now, before moving on to why we are talking about sports mediation or mediation in sports and how mediation is actually taking place in disputes pertaining to sports, let me just take you through the whats and whys of mediation. So, Fasna, you can help me with the screen share.
Yeah, give me 1 minute. Yeah. I hope, Espen, shall we start with the webinar already, or you want to address the participants as you wish?
Well, I guess we can just start the webinar. Well, first of all, thank you very much, Kangasha, for that very kind introduction. And it will be, it's a great pleasure and a great honor to be asked to say a few words about sports mediation. And I personally find the combination of sports law and mediation very interesting, as I do think that disputes in sports law often are very suitable for mediation. But for now, I think we'll just continue with the webinar, and I'll get back to you in a few minutes.
All right, thank you for that, Espen. I'll just share the PowerPoint, Akansha.
Yeah.
You see the screen?
Yes.
Yeah.
So let's talk about the need of mediation. And that, in fact, germinates from the conflict. And as we know, conflicts are indispensable part of human interaction. So whether there are neighbors, who are fighting over car parking, or they are partners who are relentlessly complaining about the lack of attention or time that they are giving to each other, or co-workers who are not ready to work at a shared place. Due to differences in opinions, preferences, ideologies, conflict happens. So what happens when there is a conflict which has arisen? We approach a conflict resolution mechanism. And even today, court is the most often approached mechanism for resolution of conflicts. But before conflicts, the parties are treated as adversaries, which means they are opposite to each other. They cannot coexist, which means when one wins, the other loses. But is justice also a contest? No. Justice is when you feel that your issues have been duly addressed and they won't be repeated in future. So what do we do in that case when courts are not able to answer all our issues? So some great minds thought of maybe talking that can help us through our issues. So can we really talk through our conflicts, through our issues and resolve them? We can, definitely, but there arises a problem. When the parties are already angry with each other, they're not ready to listen to each other, they further increase the probability of clashes. So what do we do then? We bring a mediator who performs an assisted negotiation to lead to the resolution of conflict. That means this mediator would help you communicate, would help you to bring all your issues before the other party so that you can together come to the reasons, to the solutions that you want. Now let's see one definition of mediation to put what we have discussed as of now. So mediation is a negotiation which is facilitated by a trusted neutral person. A person who has impartiality, cannot favor any of the parties. The role of the mediator is to help those who are involved in any issue to sort them out and receive and arrive at a consensus. And that might involve helping parties to finalize an agreement, the solutions that they have designed, resolve their dispute, develop effective communication to address all the reasons of why conflict arose, build and improve their relationship to make it futuristic, and all the other things to give 100% resolution and satisfaction to the parties at conflict. And as I said, being a neutral mediator cannot take sides. The person has to be impartial. With this on the point definition, let's see what are the benefits that mediation offers. Now, some of you might be able to identify all these benefits. So let me just take you through all these benefits. The first step towards when you're going towards mediation is voluntariness. That means parties at their own will, they proceed towards mediation. You cannot force anyone to take up mediation as a mechanism for conflict resolution. Confidentiality. Whatever is discussed at the mediation table does not go beyond that table. And also, the second level of confidentiality comes when a party discusses any information with the mediator without the permission of that party, that information cannot be shared with another party. Then comes two very important points of saving time and saving money, which are becoming constraints in the court system due to heavy pendency. Mediation becomes a futuristic conflict resolution method where the parties, with the help of effective communication, are able to look at a relationship in future. So that when they look at each other in the future, they do not become angry. They're able to walk past what happened in the past. Then comes the win-win situation. Here, justice is not a contest. both the party win equally. They come to a solution where both the parties are equally satisfied. And this happens by increasing of the pie, which means the solutions which were earlier offered by the court system, here they can be designed. So what is not there in law can become a solution here because parties are designing the solutions themselves. And mediator only helps them through this designing part. So mediator, we can say, is controlling the process, but the parties are controlling the outcome. With this, there are more ideas which are generated. And again, the mediator can help in generation of the ideas. After the entire process is completed, it results in a greater satisfaction of all the parties who are involved. So the emotional meter that we are looking at on the screen, right in the middle, is how parties travel from being angry towards being happy when they arrive at a solution which answers all their needs. So with this, I come to an end of what's and whys of mediation. In case you have any query, you can put that in the chat box. I can take that up through the presentation. And now I would hand it over to Upasna to talk about why we are dealing with this topic today. Thank you, Vasna, and thank you guys for listening.
Thank you, Akansha. That was very, although I've heard these things before, but it was very interesting. Like very interesting. So let me just share my screen with, I'm going to talk about why mediation in sports. So Espen, please pardon me if I'm talking anything, as in I'm saying something which is not bang on correct. So you can you can tell me whatever improvements I have to make in this. So is my slide visible?
Yes.
All right. So I'm going to share it. Just yeah. So we are talking about mediation and sports dispute. So mediation as a mechanism, dispute resolution mechanism, is gaining pace. In the past 10 years, we have, in India particularly, we have seen a lot of enthusiasm with respect to mediation. However, globally, mediation has been accepted as a popular dispute resolution mechanism, maybe for the past 25 years. But in the case of sports dispute, mediation still remains underused. And quickly we can say that maybe mediation is new, or the entire dispute, the sport dispute arena is dominated by arbitration. Maybe mediation didn't give positive results when it was originally introduced. But these can be the reasons for mediation remaining underused in sports dispute. And this is the reason why we are doing this webinar today, because sports industry is a very it's a huge industry, and there are conflicts maybe cropping up daily in the sports industry, and definitely the conventional legal system is not helping. So we are going to discuss why mediation in sports dispute. So anybody knows who this person is? Espen, maybe you know, but this was a
no, it's a familiar face, but I can't remember his name.
All right. So he is the Deputy Director of Federal Mediation and Conciliation Service, Scott Beckenbaugh, and he was a celebrated dispute resolution expert back in 2012-13, and his name was everywhere on the internet. And hockey fans, he was sort of a hero to hockey fans for a while, because like there was this big NHL lockout, National Hockey League lockout in 2012-13, and he was the person who intervened magically, and he solved that dispute. And we could see on the left, I have put the screenshots of the news reports there on Google. So he was like, NHL lockout over, mediator credited for extraordinary contribution to New Deal. So he was how mediation saved the National Hockey League. So that was the time when mediation, it was already gaining pace, but it became quite popular when Scott Beckenbaugh, he mediated and facilitated the discussion between the National Hockey League and the National Hockey League Players Association. So what was the, so you can go to the Harvard website and there's this very interesting case study given on this dispute, National Hockey League lockout. And so it was in July 2012 when the NHL, it offered its new collective bargaining agreement to the association, Players Association. And the agreement had this term which reduced the players' percentage of hockey-related revenue from 57% to 43%. Now, this was the act done by NHL that offended the players unanimously. And after waiting a month, the Players Association, they put forward their offer, and obviously it was not accepted. By September, the previous contract was over, and now there was no new contract because collective bargaining did not, that agreement did not take shape. So there were weeks of cancelled games which converted to months, and the dispute was going on. Then there was a breakthrough. Scott Beckenbaugh, he entered the discussion, and he changed the that deadlock oriented discussion, that negotiation was, which was almost impossible. What did he do? We'll just see. But if you want to give a read, this book by Deepak Malhotra, Negotiating the Impossible, is quite interesting. You can give a read to that. It talks about the techniques involved in difficult negotiations. So what did he do? What did the mediator do? So as I've already discussed, the main issue of contention was the reduced salary. That was the immediate loss that players were experiencing and they were feeling. So what did Beckenbaugh did? So he expanded the focus by looking for trade-offs. He introduced, so the agreement was finally done on the issue of pensions, player pensions. The agreement allowed NHL players whose careers are often short to concede on the short-term issue of salary in return for peace of mind regarding their long-term financial future. So there was Scott Beckenbaugh expanded the pie, just like what Akanksha told, and he sort of facilitated, encouraged the participants to expand focus and look beyond the immediate future. And when you start looking beyond the immediate future, you may be able to identify new sources of leverage and to resolve your dispute. That was the issue of pension here in this agreement. And then finally, when the face-to-face negotiations, they became quite heated. That was the case in this case study, the player association and the league. The discussions between the representatives, they become so heated that many a times the discussions were not concluded and they had to return and the impasse continued. So what did he do? He introduced the shuttle diplomacy. So in the winter month in New York, so it was the later half of the year, and on the frosty evening, he was doing some shuttle diplomacy between two parties. So in that, there was for about 12 hours, there was this discussion. He was discussing individually the issues with both the parties in different rooms. And by visiting each side in turn, he identified the issues where there can be flexibility from the participants. So that was the issue of pensions, where the egos were not absolutely rigid, and they decided to back off and arrive at an agreement. So he saved a lot of matches there. So the fans were really happy, and the lockout did not happen. Then what are the benefits of mediation in sports dispute? So there's this Professor Mark Grabowski's article, Both Sides Win, Why Using Mediation Would Improve Pro Sports. So he argues that the type of conflict that often arise in mediation, like labor disputes, disciplinary disputes, broadcast dispute, they are ripe for resolution with mediation. So we can say that the subject matter of dispute in conflicts that arise in the sports industry, they are ripe for resolution via mediation. And other than that, if we go for the second benefit, as in why mediation can be introduced in sports dispute, is that the privacy and confidentiality element. So vocal third parties ranging from sports agents to fans, they often come in the way of an agreement in sports dispute. So because mediation is a confidential, fast track and cost effective process, it allows parties to create and design face saving compromises. Then next is a win-win agreement. So why is it important? Unlike arbitration, which is the popular dispute resolution mechanism currently in sports industry, it's not a lose and win situation. It is a win-win situation. And parties, they have greater control. So on the outcome, they have greater control over how mediation unfolds as compared to arbitration or litigation. That results in more productive relationships. The arbitration process, for example, in arbitration, the offer is take it or leave it all. So it's either you win or I win. It's not just like I said in the previous slide. So it results in an impasse or damaged relationships, just like litigation, that hinders players' performance on the field. However, in this confidential and collaborative process of mediation, the process is far more likely to preserve and even improve the relationships between players. And that reflects on the field. The team plays better, the teams together, they play better. So that the management and the team relationships are better. And everything it is manifest on the field when the players play and the fans are happy. So that is what matters in sports industry. So that is why mediation is a proposed dispute resolution mechanism, which can be more beneficial. So Espen, over to you. I hope I did not say anything wrong there.
Oh, sorry.
Yep.
Just needed to unmute. Can you see my presentation now?
Yes, it's visible.
Very good. Well, thank you very much, Apasana. That was a very interesting presentation. I understand that many of you have a lot of knowledge about mediation. However, just to make sure that everyone's on board, let me give a short summary of what mediation is and what my experiences with mediation is. And although my experience is based on mediation in sport disputes, I think that many of these experiences may be common to many other types of disputes as well. Traditional disputes, as Upasana and Akanksha has said, disputes will be resolved either by in ordinary courts or in arbitration, where the dispute finds its solution in an award that is based exclusively on the arbitrators or the judge's assessments of the relevant legal framework seen in relation to the actual circumstances of the case. In such a settlement of a dispute, one of the parties will normally appear as the winner, while the other party will be the loser. But for all parties, including the winning party, a process through the courts will be demanding and costly. In addition to the cost for their own lawyers, the parties will normally spend a lot of time and resources preparing and conducting a case before the courts. And a dispute before the courts could also be harmful to the parties' future cooperation. And as Akanksha and Apasana has said, a cheaper, faster and less risky alternative to court proceedings and arbitration is mediation, where it will be possible to achieve good solutions, also in cases that involve several parties and in complex cases. One advantage with mediation is that it allows the parties to take into account continued future relationships, as well as financial considerations. You can take into consideration what seems fair, what seems morally right, and solutions that satisfied the underlying consideration or needs of the parties. The process of mediation will normally begin with either one or both of the parties contacting the mediator in order to schedule mediation. And then the mediator will provide the parties with information in advance of the mediation and guide the parties through the mediation process. Then a pre-meeting will normally be agreed where the parties and the mediator agree on practical matters, including the time and place of the mediation. And then the mediation process itself normally takes place physically, either in the mediator's meeting rooms or in other suitable premises. During the mediation meetings, the parties can normally choose whether they want to participate with a lawyer. And this is normally clarified prior to the mediation meeting, as it could create an imbalance between the parties if only one of the parties are represented by a lawyer. If lawyers do participate in mediation, it is important to be aware that the lawyer's role in a mediation will differ from the lawyer's role in a process before the courts or in arbitrations. While a lawyer during a court hearing will focus on presenting the evidence and arguments that will convince the judge or the arbitrator that the lawyer's client should win, the focus in mediation will be on the interests of the parties and not on the law. So the mediation meeting itself, that would normally start with a joint session where the mediator and both parties are present. In the joint session, one will go through the actual aspects of the case and try to reveal what interests the parties have in the case. After that, one will usually continue in caucus meetings, which means that the mediator will talk to the parties separately in separate rooms. And in such caucus meetings, it is important that the parties notify the mediator of all the aspects of the dispute, including interests and views that the party does not wish to notify to the other party. The purpose is that the parties in such caucus meetings will be able to provide information to the mediator about the interest they have in the case and express how they want the dispute to be resolved. The mediator has a duty of confidentiality and then only notify to the other party that the party itself allows. And then once the mediator has uncovered all the factual sides of the case and revealed the parties' strong and weak sides, the mediator can begin his work of presenting a solution together with the parties. And if the parties do reach an agreement, the mediator will contribute, at least normally will contribute to drafting the agreement. And even if the mediation is not successful, the mediation could still be useful for the parties. Through mediation, the parties gain insight into the other party's views, which can contribute to the parties reaching an agreement at a later stage. When it comes to mediation in sports, we normally distinguish between institutionalized mediation and ad hoc mediation. Within the institutionalized mediation, an institution will be responsible for organizing the mediation within a set legal framework. Whilst in ad hoc mediation, the parties agree on a mediator who will organize the mediation. Typically through a law firm or a mediation center. Within the international dispute resolution centers established in sports that actually offer mediation, there are two main institutions, the Court of Arbitration for Sport, or the CAS, and FIFA. Internationally, the Court of Arbitration for Sport is the most well-known dispute resolution center, as almost 1,000 disputes are settled on a yearly basis. Although most of these cases are sold through arbitration, CAS also offers mediation. And in practice, in every dispute before CAS, the parties are informed by CAS that CAS offers mediation. I'll just give you an example of such letter that is sent to the parties in almost every dispute that is sent to the CAS, and then the parties will be requested to clarify if they accept that the dispute is referred to mediation. Must be said that although the parties are always offered mediation, it's still a bit of early days for mediation in CAS as well. I would think that on a yearly basis, I would think that somewhere between 30 and 50 cases are referred to mediation, while almost 1,000 cases are referred to arbitration. So it's still a long way to go, but at least it is a system that is up and running, and the mediators are very well qualified. If the parties then accept to refer a dispute to mediation, CAS will, in cooperation with the parties, agree on one or more mediators that will mediate in the disputes. And once the mediator is chosen, the parties will meet in a traditional mediation process. Just now, FIFA is also about to offer mediation. Was made by FIFA only last year, and a few months ago, FIFA published its list of mediators, which consists of 18 persons. Just to say that I just spoke to Apasana before most of you joined, and I understand that cricket is by far the biggest sport in India, but you probably know that football is a worldwide sport with the vast majority of the disputes in international sports is actually within football. So for that reason, FIFA establishing its own mediation center is very important within sports law. A requirement for FIFA to offer mediation is that the dispute has an international dimension. And the criteria of international dimension will typically be fulfilled if the parties have different nationalities. For example, in a dispute between a football club and a foreign football player, or between two football clubs from different countries. FIFA's judicial bodies, they handle several thousand disputes every year. So it will certainly be exciting to see how many disputes that will be referred to mediation once they have it up and running. As FIFA only offers mediation in international sports disputes, domestic sport disputes will normally be referred to domestic mediation. I'm not sure how that works in India, but at least in Norway, sports mediation for domestic disputes would be conducted ad hoc in accordance with other types of mediation, as there is no mediation center that specializes in domestic sports mediation. So in practice, the parties to a dispute would therefore have to contact a mediator from a closed list of mediators with competence within sports law in order to start the process of mediation. I often get the question, what types of disputes are suitable for mediation? And in my opinion, sports mediation will be a favorable way of resolving disputes in all cases where the parties have a desire to be involved in determining the outcome of the dispute. In particular, sports mediation will be beneficial in disputes where the parties involved will benefit from having a relationship even after the dispute has been resolved. Many sports disputes involve clubs and athletes that have had a relationship for a long time and that will continue to meet on a regular basis also after the dispute has been settled. And furthermore, sports disputes where the claim is relatively modest in relation to the costs of court or arbitration proceedings will be suitable for mediation. Now, the sports mediator is normally a person who has specialized in sports law and dispute resolution, although it's not formally a requirement that mediators are legally trained. Further, the mediator will have training as a mediator, naturally, and it would normally be beneficial if the mediator has experience within the sports industry. For example, in a dispute between a football club and a football player, a mediator with experience from the football industry who knows how the football industry works would probably have better basis to help the parties settle the dispute than a mediator without experience from the football industry. Same goes, of course, for the cricket industry. Would be beneficial to have someone who has experience from cricket and from the cricket industry to act as a mediator. Also, a mediator with legal training and experience from the sport industry will be able to give the parties input with regards to the rights and obligations that would be useful regardless of the outcome of the mediation. Traditionally, sports mediation is conducted physically. In CAS, for example, it's located in Lausanne in Switzerland. And traditionally, the mediation process takes place in Lausanne. In some cases, they are actually the mediator has traveled to the parties, but it's very often conducted physically, and the parties will then meet face to face. However, during the COVID pandemic, it became quite common to carry out mediation digitally, and there are several digital solutions that proved well suited for mediation. Personally, I think that digital mediation has some clear advantages, in particular in international sports disputes where parties may be located far away from each other. A few weeks ago, I was involved in a dispute between a club from Brazil and a club from China. And in such a case, it would be meaningless for all the parties to spend days of traveling. So in such a case, digital mediation is much more easy to accommodate. However, at least in my opinion, in more complex disputes, I think it is an advantage to meet the parties in person, as I find it easier to establish trust between the mediator and the parties if you meet in person than if you meet online. And I think that is the trend as well, and I'm quite convinced that in the future, most small sport disputes will be conducted digitally, whilst the more complex ones will be conducted in person. I think that wraps up what I had planned to say. Please feel free to ask questions in the chat.
So, Espen, there are a few questions sent. Thank you for the brilliant presentation, Espen. There were few questions sent to me in the private chat, and there are few in the common chat. Let me ask the common ones first. So, Mohammed Abdul has asked that he's from Bangladesh, and his question is, how should he become a sport lawyer?
Okay. Well, at least in Norway, the sports law community is rather small. So I think that if you want to be a sports lawyer, it's necessary to find experienced sports lawyer who is able to take you on board. and that might be, it could be in law firms, it could be in clubs or in associations. Personally, I started my sort of sports law career in the Norwegian Football Association, where and the benefit of that is that you are thrown straight into sports law issues on a daily basis. I think that many law firms, they have sports law as part of what they do, but it might be a challenge to find enough sports law to become specialized. So if you have the opportunity to work with law in a club or in an association, I think that would be a great way to start a sports law career.
Thank you for that answer. I hope, Mohammed, your question is answered. Then there is this question from Saksham Tiwari. So is there a difference between an individual approaching and so I think the Saksham, please correct me if my understanding is wrong. So I think the question is that if there is an individual involved in a dispute and a club involved, so is there a difference when there is a club or an individual involved in a dispute? Is that right, Saksham? That is what you wanted to ask?
Yes, ma'am.
All right.
Okay. In practice, I think it is. In my experience, if you have professional parties like companies or entities, it will normally the parties will not have such a emotional relationship to the disputes, and it will sometimes be easier to come to a good result because it's all normally it will only be about, money will be at least an essential issue, whilst in individual disputes when the individual is involved, it can sometimes be difficult to come across to move away from sort of the high tension between the parties and move on to the parts of the dispute that might lead to a resolution. At the same time, with companies or entities, it's always it's important, of course, to reach out to the right people. I've been in mediation processes where the representatives from the entities haven't got power of attorney that enables them to reach a solution. So it's important to prepare the parties and make sure that they have the right power of attorney, and that they might actually sign an agreement if you reach one.
Okay, I think that was really insightful. Okay, the next question is from Wala, and she is asking, how can I join the panel of neutrals for sports mediation?
It depends on, I would possibly recommend to start mediation domestically. I think that at least in CAS and FIFA, which are the big international dispute centers, I think that you probably will need quite a bit of experience to join. So I'm not quite sure how that works in India. In Norway, at least, it starts with training. You need to be certified, and in order to be certified, you need to do the training. And in my experience, once I did the training, you sort of become a part of a community of mediators, and within that community, you could discuss, of course, career possibilities as well as mediation itself.
Yeah. So, Espen, just a follow-up question there. Is there a special training required for sports mediators, or the training is common?
No, the training is quite common. In at least in Norway, there's one training for all mediators, but once you are certified as a mediator, the mediators tend to specialize in different subjects. Of course, so quite a few of them specialize in real estate. Some of them specialize in labor law. In sports law, it's not many of us, but it's at least it's me and a couple others who are very interested in sports law. So but do the training and certification first, and then specialize after.
And I think
I have
yeah, please go ahead, Akansha. Yeah.
I was just saying that there is one question related, somewhere related to how Esperi answered this. So the question is, how sports mediation is different from others mediation. So when we're talking about what special skills would be required, what special training would be required, because in other mediation, traditionally when we see mediation, it is mostly applied to family related disputes, matrimonial disputes, where parties are more emotional.
Yep.
So sports mediation is certainly different. So what are these key differences and what would be the, okay, so Anand has asked what are top 3 skills that a sports mediator would then use in resolving these disputes.
Yeah, well, there are some parts of the sports that makes it. Well, for example, many disputes are between athletes and clubs, labor-related disputes, and I think it's quite important to be aware that an athlete's career might be quite short. You know, it might be on top of his career for say a period of 10 years. So if the athlete is in a dispute with a club, it is very important to make to the time aspect of it, because only if in a normal mediation procedure it could take months before you sort of get to the mediation itself, but in a labor related sports dispute, it is very important to get the parties to agree on a settlement quite soon, because it'd be very damaging for the athlete to wait a long time for it. And of course, there are quite a few disputes between clubs. Both parties are clubs, and in those disputes, they are normally based on the sports regulations rather than national law. For example, in football, FIFA has its regulations that is more or less compliant, that all clubs and associations would have to comply with. And if you're not familiar with those regulations, it will be very difficult to try to find a solution, because the solution will have to be in the interest of all parties, and a wrong decision could cause some problems for the parties later on.
So just to summarize, Espen, what you have mentioned. So one thing which is related to this is time, the cruciality, how mediator would manage, because in other mediations, the mediator would try to take it very slow so that parties can bring forth all the issues and there is a complete resolution. But in sports mediation, the mediator would have to be very careful of the time, because like you said, it is the entire career of that person, that sports player, which is dependent on that mediation. And secondly, that you mentioned the knowledge of the national law, which is certainly important. So just having that training of mediation is not the only thing that you would, it's not enough. Unless you know the nuances of the law which is applicable, you'll not be able to deliver all the requirements to the parties, if I'm not wrong there.
Yeah, I think thank you for that answer, Espen. That clears a lot of doubts even in my head. So another question is by Karan. So Karan, I read your question, and so specific examples, I might not illustrate the specific examples, but yes, even mediation is getting introduced in a lot of pending bills in India also. There was this case by Rajiv Datta. He was an advocate, I think, who filed a case in it was a matter of a boxer, female boxer, and she was treated very arbitrarily by the International Boxing Association or Indian Boxing Association. So there was this request to introduce the guidelines of CAS, the Court of Arbitration in Sports. So introduce a few of the guidelines from there in India, in the Indian context, and it was done. There was this, so there is this prevalence of settlement procedures. We cannot say that they are exactly mediation procedures, they are exactly arbitration procedures. But quite recently in Ahmedabad, I think an arbitration center has been opened which deals specifically with sports dispute. So I think that is something that that we can look towards. Then another question is from Espen. I'm just, there's some. Then kindly share PDF or training. Then Webhavi has asked, how are the sports disputes different from other mediations in terms of experience? I think that question has been answered. Okay. Okay, so I think the questions which we have already discussed answer more or less all the questions in the chat box. There are two questions of my own, Espen. How popular are caucuses in Norway, the mediation landscape in Norway? As in, because in US I know that the shuttle process is quite common, but in India, for example, we do caucus. We go in private sessions only when it is required. So how common? Yeah.
Well, in Norway, you would almost always start with a joint session, and then once you sort of realize that you're not getting anywhere in the joint session, you'll go into caucus sessions. But I know that, and I think that that is quite common way of doing it in Europe. I recently spoke to an American mediator from California, and I know that in California it is quite common to go straight to caucus sessions. But in Norway, you almost always start at the joint session and then move on to the caucus sessions later on.
That's very quite interesting. And why do you think that? Is it the cultural difference, or maybe just your view? Why is some jurisdictions more open for caucuses and some not?
It's difficult to say. I think that at least when I did my certification, there were, they explained the reason why we start with a joint session and then move on to the caucus sessions. And I think that if you skip the joint session and go straight to caucus sessions, you will probably could be a bit more distance between the parties. I think that if you quite a few, normally, at least in more complex cases, there will be several issues that will have to be resolved. And in my experience, in a joint session, you can early address a few issues that are not really important to the parties, and such you can just take them out of the way, and you can sort of focus on the issues that are really important to the parties. So, I know I'm Norwegian and European, but I'm a very strong fan of that way of mediating, I must say.
All right. Okay, Espen, thank you for that. Before I go to the next three interesting questions in our bank, I just want to briefly talk about our upcoming mediation training. So that is what we were talking about when we met. So let me just share my screen quickly and talk about our Espen, that my screen sharing would override your screen sharing. Sorry.
There you go.
Thank you very much. I didn't even realize that. Yeah. All right. Is it visible?
Yes, it has started sharing.
All right. Thank you. So Akansha has already discussed about Accords International. I think you can all follow us on our LinkedIn. Our social media handle has been shared by Prateek. Our website link, Prateek can share in the chat box. I would quickly talk about the project Mediate Early, that few of the neutrals under Accords banner, we came together and we started the project Mediate Early to provide mediation trainings and make them approachable for young professionals and students. So they can be students, law students, or irrespective of their background, they can be from any background, professional background. So we have launched a 60-hour accredited learning program in mediation in collaboration with Mediation Academy. And we are accredited by ADR Register Global Network Group, Amsterdam. And in these 60 hours, we are offering 45 hours of contact hours and 15 hours of assignment report writing and readings and other activities. Then it will be a 6 days of learning program. And on the day one, we will introduce what is mediation, what is the mediation landscape, what are the laws related to mediation. And then on the second day, we will talk about mediation principles and ethics and dive deep into the opening statement, the elements of opening statement. There will be rehearsal role plays. There will be a lot of role plays on day two. Then on day three, we will be talking about communication, verbal and non-verbal communication. What is negotiation, bargaining? What is assisted negotiation? We talk about negotiation in every mediation training, but why are we talking about that? Then on the fourth day, we will be talking about how to handle emotions, how to handle impasse and deadlocks. And then again, the entire day of rehearsal role plays. On the fifth day, we will be talking about the role of mediator, documents, what are the relevant documents in mediation, what is restorative mediation, and then popular practices in mediation, again, role plays. And on the day six, before the assessment, final assessment, independent assessment, there will be way ahead as a mediator. Once you have the training with you, what next? So after that, we will be getting the top skills from the mediation. I'm not saying that only this training will give you these skills, but this training will also give you these skills and beyond that also. So active listening, trust building, time management, handling emotions, being impartial and neutral, critical thinking. Then our faculty is, we are offering a diverse set of faculty members. So while Victor is from Nigeria and he's a James Feinstein Fellow, he's an international mediator, Eden is also a writer and a conflict resolution specialist. Joe is also an arbitrator and a mediator in the Florida Supreme Court. Then Barry is an international mediator. He specializes in family mediation. He's from South Africa. AJ Jawad is the Supreme Court trainer in India, and he's an accredited digital dispute resolution specialist. Mihir is an advocate and a certified mediator. Then Arpit is a policy expert, public policy expert. And again, he's talking about how a policy change is needed. Sahal is a restorative practices mediator. Sulekha is a lawyer, consultant, qualified dispute resolution expert. Then me, Akansha and Rima, we are also, I have done my training from London School of Mediation, and I've been practicing here in India, and private mediations are something that I focus on. I'm also a lawyer and a negotiator. Akansha is a restorative justice facilitator and a mediator. So Rima is again a Supreme Court trainer. So we are offering a very diverse category of faculty members. Then why should you train with us? So we are focusing on peer mediation, role plays. We are focusing on feedback. The supervision and coaching will be throughout the training. So I think I'll thank my ecosystem partners. The last day of registration for the training is September 15. There are scholarships available. You can visit our social media handle. You can visit our website for more details in that direction. So thank you for listening to me. And thank you for patience, Espen. There is one more question that I wanted to ask from you, Espen, as in starting from where we left, that what is your hope towards mediation as a dispute resolution mechanism in sports area, in sports arena, and when it comes to sports disputes? So what is your hope with mediation?
Well, I think the biggest challenge at the moment is, of course, that there are quite few, very few cases of disputes that are referred to mediation. And I think that's a shame, because I think that, as I said, mediation is a fantastic opportunity to resolve disputes within sports. But I think that it hasn't been a rapid increase, but at least has been a slow increase in disputes that has been referred to mediation. And now we see that FIFA, which they handle thousands of disputes every year. They are now starting offering mediation as well. Hopefully that will make people more aware of mediation as a possible dispute resolution mechanism. And I hope that many cases in the future are referred to mediation compared to courts and arbitration.
One last question. So, should we advocate for institutional mediations in sport dispute or ad hoc, which gives a better sort of possibilities for parties also?
It depends on how many cases that would normally be referred to mediation within that sort of sector. I think that the reason why there's no institutionalized sports mediation in Norway is because they realize that it's not really enough cases to make it viable. So it really depends on the number of cases. In India has many more athletes and many more clubs than Norway, so it could be that if you try to cooperate, for example, with the Indian sports organizations,
right.
it could be that you could organize an institutionalized mediation center in cooperation with them. But it all depends on the number of cases, because it is quite, it takes quite a few resources to establish such an institution. So you need a few cases to justify it.
And a lot of money.
Yeah.
All right. Okay, thank you for that brilliant answer, Espen. And I think it was 1 hour well spent. We are already done with our 1 hour. Thank you for that. And any question with which our participants have other than what we have discussed, you can send us on our email ID. So yes, Saksham, Espen, if you allow 1 more minute, I think.
Yeah, of course.
Please go ahead, Saksham.
Thank you for the wonderful session, ma'am and sir. And I have a doubt, like I have some sort of observation drawn from my some sort of my research regarding Duti Chand, athlete in India. The case related to like there is a discussion going on for the testosterone level, and the Indian authorities and the clubs are mentioning that they are following the international guidelines which are mentioned for the athletes. For that perspective, if we talk about Usain Bolt, there is some advantage, like one leg is for some different from the other leg, and for the Sachin Tendulkar, there is a another set of advantages for him. So in that case, in general, when the discussion is started, the Indian authorities just reflect that they are following the international standard. They denied for being she is a woman. The testosterone level doesn't display all things. He's a better athlete. That's the first question. So in that perspective, as a sports mediator, what your stand on the same if you look a scenario coming in front of you?
Well, that's a good question. Well, I think that is a challenge in international sports. So you normally have one sports organization, one international sports organization, and that sports organization will make regulations that apply to all the national sports organizations. And those regulations may not be perfect to settle the rights and obligations for national clubs and athletes and whatever it should be. So normally what I prefer is if the international sports organization say that, well, you need a certain set of regulations, but you're free to make those regulations nationally, depending on the local issues and how it's normally regulated there. But of course, in a mediation process, it is much easier to look beyond the regulations and say that, forget about the regulations. We need to find a solution. What is the interest of the parties? How should we try to find a solution that both parties should be satisfied with?
I think so. Apologies for that, Espen. So, all right. So, thank you for that question, Saksham. Thank you for that answer, Espen. I think now we are almost 5 minutes over our permitted time and the time slot that we took from you. And I'm looking forward to another session where we can talk about specific issues cropping up in sports mediation, Espen, as your calendar permits. So thank you very much for joining us today. And
Thank you very much.
thank you all the participants for joining us today and all your brilliant questions. Hope there were few answers that were given in the past 1 hour. So enjoy the rest of your evening. Enjoy your day, Espen. Bye-bye. I'm ending.
Thank you, Aspen, for
Thank you.
joining
Bye.
us, and thank you all the participants.
Thank you. Thank you, Espen.
Saksham, are you still there?
Yeah. Yes, ma'am.
So
I'm here.
yeah, Saksham, just give me, contact me on my number. You have my number, right?
Yes,
So
ma'am.
wanted
I
to
have.
talk. Yeah. Okay.
Okay.
Bye.
Thank you, ma'am.